Hi, I'm Mindy Rice. I'm a shareholder in Reinhart's banking and finance practice, and I am going to be talking about the fascinating topic of fraudulent transfers. So we have noticed over the past few years that some of the participants, namely the bankers and the sellers in transactions that we deal with frequently, notably commercial lending transactions with multiple obligors and leverage acquisition financing transactions seem to be not as aware as we would hope of the fraudulent transfer risk that is present in these types of transactions. And so I put together the seminar, and we sort of want to talk through, what types of transactions present a fraudulent transfer risk, how to recognize it, the limited ways that you can minimize the risk, and then at least at the end you'll sort of know what you're looking for so that at a minimum you can price the transaction appropriately to recognize the risk that's inherent in these types of deals, because unfortunately sometimes that's really all you can do to protect yourself against the risk. Either choose not to participate or price it such that it's worth the risk that you're taking. One thing that I wanted to note is that there have been recent changes to the Uniform Fraudulent Transfer Act, which is the principal state statute that we'll be talking about. It's the one that's relevant in Wisconsin. In 2014, the Uniform Commission of Laws adopted some amendments, or proposed amendments, that will be made to the UFTA. The principal one that you should be aware of is simply that they're renaming the act the Uniform Voidable Transactions Act. And the reason that they did that was sort of to emphasize that fraud may not be at all present in these transactions that are still nevertheless voidable. So we'll talk about a few of the other amendments that are included. Wisconsin has not yet adopted these amendments. I think they've been adopted in about 8 states and introduced in a few others, but I would anticipate over the next few years that more and more states will adopt them. So the primary state and federal standards that we're going to be talking about are the Uniform Fraudulent Transfer Act, which is still applicable in Wisconsin, and then obviously the Bankruptcy Code, specifically Section 548. There is another state statute out there, which is the Uniform Fraudulent Conveyance Act. That's the old statute that predates the UFTA. That's still in effect in a few states. The standards under that statute are very similar to what we're going to be talking about with the UFTA, but one thing to keep in mind is that the statute of limitations varies widely under that one. So for the states that still have it, sometimes they have shorter, or what we really don't like is they have longer statute of limitations than the 4-year standard under the UFTA. So for example, I think New York has a 6-year statute of limitations. I believe California has 7-year. So you obviously need to be aware of that if you're dealing with other states. So the Uniform Fraudulent Transfer Act is codified in Chapter 242 of the Wisconsin statutes. And we're going to talk about a couple different tests. So the UFTA sort of divides the tests into transfers that are fraudulent as to, oh, I'm sorry, I forgot to advance the slides. Oh, and I forgot to mention, if you're on the webinar and you have any questions, just type them into the panel box. Okay, so we'll come back to these slides. All right, so here we are. So again, there's 2 sets of tests under the UFTA. So transfers that are fraudulent as to present and future creditors means that you don't have to find somebody who was a creditor at the time that the transfer was made. If someone is a creditor at the time that the transaction is being challenged, so 2, 3, 4 years after the transfer was made, that will be good enough if you meet these tests. the first test is the actual fraud test. So transfers made or obligations incurred with actual intent to hinder, delay, or defraud any creditor. The typical example here is some guy has a car loan, he gets into financial difficulty, he transfers title to his car to his brother-in-law so that the bank can't foreclose on his car. This will typically be deemed to be a transfer that was meant to hinder or defraud his creditor. Usually he keeps the car, he doesn't give his brother-in-law any money, he just does it so that his creditor can't get at the car. Fortunately, that's relatively rare with the transactions that we deal with. More typical in our context is constructive fraud, so no actual fraud is required here. These are simply transactions that meet these tests. The transfer was made or the obligation was incurred without receiving reasonably equivalent value in exchange, and the debtor, I forgot to advance the slide again. Okay, and the debtor either was engaged or was about to engage in a business or transaction for which the remaining assets of the debtor were unreasonably small in relation to the business or transaction, or the debtor intended to incur or believed or reasonably should have believed that the debtor would incur debts beyond their ability to pay as they became due. So these are transactions that are going to be fraudulent transfers as to the whole universe of creditors, people that exist when the transfer is made and people that become creditors after the transfer is made. The most likely category of people is trade creditors. So then you've got a separate category of transfers that are only fraudulent as to present creditors. So you have to find somebody who was a creditor at the time that the transfer was made and is still a creditor at the time that the transfer is being challenged. These are certain transfers to insiders and then transfers made or obligations incurred without receiving reasonably equivalent value in exchange for the transfer or obligation, and the debtor was insolvent at that time or the debtor became insolvent as a result of the transfer or obligation. That is a little bit harder to prove. Oftentimes the case law is going to the claim is going to be made and the case decided under the first test that we talked about, because it's a little bit more difficult to show that someone was actually insolvent on the day that the loan or the leverage acquisition happened. Keep in mind that under the bankruptcy test, there's sort of no distinction between these two categories. It's just all there was no reasonably equivalent value, and either you were actually insolvent, you were left with unreasonably small capital, or you believed or reasonably should have believed that you would incur debts beyond your ability to pay. The other thing to keep in mind is that the bankruptcy trustee can step into the shoes of any state law creditor. So even if you're past the 2-year bankruptcy statute of limitations, but there's a creditor under state law who could have brung one of these two types of claims, the bankruptcy trustee will be able to bring that claim as well. Okay, so now we're going to go back to the front slides, the structure slides, and just sort of talk through this a little bit so you can see how it plays out. The problem with both leveraged acquisitions and multiple obligor debts is that for many of the participants, you're going to fail the reasonably equivalent value test. And so keep in mind, you have to fail both prongs of the test. It has to be no reasonably equivalent value, and you have to be either insolvent or left with unreasonably small capital, or left in a situation where you should reasonably anticipate you won't be able to pay your debts as they become due. So in the first acquisition scenario, here you can see this is fairly typical. You've got a target company. They incur debt and grant a security interest to the lender to the buyer and target. So usually you've got either a situation where the buyer and the target are co-borrowers, or the buyer is the borrower and the target merges into the buyer shortly after the transaction, or the target guarantees the debt. Oftentimes, though, usually the target is they're always the principal person for whom the lender is relying on their assets in terms of underwriting the loan. But as you can see here, the money is all going not to the target, but to the seller or the seller's lender. So you could say that, say, in this instance, $10 million is going to the seller's lender. That's really for the benefit of this target because that was target's old debt. But $40 million of the purchase price and $35 million of the loan is going to the seller. So in this situation, the court is likely to find that the target did not receive reasonably equivalent value. Nancy? And so the case will then come down to whether the target was insolvent at the time that they made the transfer or incurred the obligation, or if the target was left with unreasonably small capital. And feel free to jump in with any questions if you have any. So next we have the guarantee scenario, and this one it's sort of even clearer because here you can see both the circumstance where it's not reasonably equivalent value and where it is. So the loan here is made from the lender to a principal operating company, which is the borrower. Then the lender picks up guarantees and security interests from the parent and from a subsidiary of the borrower and from a sister company of the borrower. In terms of the transaction between the lender and the borrower, you're not going to fail the reasonably equivalent value test because the borrower is getting reasonable equivalent value. Say they're granting a lien, if they're incurring debt of $50 million, they're granting a lien on all their assets, and they're getting a $50 million loan. So in that case, the court is going to say, well, that's reasonably equivalent value because you incurred debt of $50 million, you got $50 million. You're also going to be okay on the parent level. The parent is providing a guarantee and security interest. Courts will usually allow parent guarantees because they view that as getting reasonably equivalent value from the benefit that they're getting in terms of their enhanced equity position in the borrower from the benefit that the borrower is getting from the loan. So parent guarantees are usually okay. The debt between the borrower and the lender, that's fine. Even if the borrower was insolvent at the time that the transaction was made, although that would be a loan that you probably wouldn't have wanted to make, it will not be a fraudulent transfer because you will have reasonably equivalent value. However, with respect to the subsidiary guarantee and the sister company guarantee, you run into problems because they are not getting the proceeds of the loan, but they are incurring the guarantees and granting liens on their assets. So it's typical for a lender to want to pick up sort of everybody in the chain of companies that they can get in terms of credit support, but they should be aware that that may not really have all that much value because absent an unusual circumstance where you can show sort of indirect benefits to that subsidiary or sister company, which you should document if there are any, those are usually not going to be perceived as having reasonably equivalent value, so then you get into the question of whether those entities were left with unreasonably small capital or were insolvent at the time that they incurred those guarantees. Okay. So we're going to go back and talk about some of the definitions that are used in the statute. So going back to the actual fraud test, obviously that requires somebody have the intent to defraud their creditors. Very difficult to tell what someone's intent is because it's subjective. So the statute has a list of what are called badges of fraud. So in Section 242, there's a list of various factors that the courts can consider in determining whether someone intended to defraud their creditors. Some of those factors overlap with the constructive fraud test, such as whether the debtor was insolvent or became insolvent as a result of the transaction, but others didn't. One of the big ones is whether the transaction was disclosed or concealed, whether the debtor absconded with assets, whether the transfer included all of the debtor's assets, and the insider status of the person to whom the transfer was made. So just be aware of that if you're dealing with a situation of actual fraud. So obviously one of the principal definitions that becomes crucial in this determination is insolvent. Under the UFTA, a debtor is insolvent if the sum of the debtor's assets is greater than all of the debtor's assets. Sorry, I keep doing that. If the sum of the debtor's debts is greater than all of the debtor's assets at a fair valuation. This is not a balance sheet or book value test, and a debtor who is generally not paying their debts as they become due is presumed under the statute to be insolvent. It's a rebuttable presumption. The debtor can introduce evidence that that's not the case, but if the debtor is not generally paying their debts as they become due, they will be presumed to be insolvent for purposes of the test. Unreasonably small capital is unfortunately not defined in the statute, but courts have generally held it to mean that the debtor is left with such a small capital that insolvency is reasonably foreseeable. So what that means is usually this is going to turn on whether the financial projections were reasonable. Because how do you determine if solvency is reasonably foreseeable? Well, the best way in terms of the transactions that we're looking at is looking at the financial projections and seeing if they show for the life of the loan or the next few years, preferably for longer than the statute of limitations, that the debtor is profitable, is paying their debts as they become due, then that is likely to be good evidence that insolvency was not reasonably foreseeable and that therefore the debtor had sufficient capital, that it wasn't an unreasonably small capital. There's various factors that the courts look at in evaluating the projections that we'll talk about, but that's oftentimes where the bulk of the litigation lies, because as we talked about, usually the reasonably equivalent value is sort of a fail, at least when you're talking about leveraged acquisitions or subsidiary or sister company guarantees. And so you sometimes see litigation about whether they were actually insolvent, but it's somewhat easier, obviously, to prove that someone was left with unreasonably small capital, so that even if they weren't actually insolvent, they should have known that they would become insolvent over the next short period of time. And the problem for the transaction participants is that the consequences of finding a fraudulent transfer are pretty severe. The creditor can recover judgment for the value of the asset transferred or the amount necessary to satisfy the creditor's claim, whichever is less. And recovery can be obtained from the first transferee of the asset or the person for whose benefit the transfer was made, and any subsequent transferee other than a good faith transferee who took for value. So basically that means that in practice, lenders are very much at risk. Sellers in a leveraged acquisition are also at risk. So it's a circumstance where, and we'll talk a little bit, I'm skipping ahead to the next slide. I'll just, basically, the consequences of a determination that a transaction is a fraudulent transfer are pretty severe. The liens and the guarantees are invalidated, and the debt is subordinated to trade creditors. So Obviously, in the typical case, a lender would not have agreed to make a loan either in a multiple guarantor scenario or in a leveraged acquisition if the transaction was unsecured. And so, and also, sort of having the debt subordinated to trade creditors is a very significant penalty. So you want to be careful when you're in these transactions that you're taking steps to minimize the risk to the extent that you can. And then going back, I mentioned the statute of limitations under the UFTA. Generally 4 years for constructive fraudulent transfers not involving insiders. It's 1 year for transfers made to insiders for an antecedent debt. It can be extended beyond 4 years for actual fraud to a period 1 year after the transfer obligation is or reasonably could have been discovered by the claimant. There are certain exceptions that can lead to even longer periods. As we talked about under the Uniform Fraudulent Conveyance Act, some states have longer statutes of limitations. In addition, the IRS can recover for up to 10 years under certain circumstances. So obviously, the farther out you get from the transaction, the more likely you are to be able to show that you sort of insolvency wasn't reasonably foreseeable, because if something happens 3 years or 5 years after the deal, then you're more likely to be able to show, oh, something bad happened that wasn't reasonably foreseeable, and not just borrower didn't have enough capital to proceed going forward. So the farther out you get, the better off you are, even if you are still within the statute of limitations. Okay, and then I just wanted to talk a little bit here about the other changes that are being made to the Uniform Fraudulent Transfer Act in those amendments that will rename the Act. One of they're clarifying some of the burdens of proof. They're also adopting a uniform choice of law provision so that debtors' place of residence, if it's an individual or its principal place of business, will be sort of the uniform standard at the time that the transfer was made. That's the state whose law you will use. The thing to note here is that it's slightly different than Article 9. So if you're used to dealing with the state being the state of incorporation or organization, that will not always be the same state that will be used under the Uniform Voidable Transactions Act, because they will use the actual state where the principal business is done, which will obviously for all of those corporations incorporated in Delaware be different than Delaware in most cases. Okay. All right. So, as you talked about, a general grant of a lien on assets to secure debt will generally not be a fraudulent conveyance or fraudulent transfer, because the UFTA states that value is given for a transfer or an obligation if, in exchange for the transfer or obligation, property is transferred or an antecedent debt is secured or satisfied. So a transfer for security is ordinarily for reasonably equivalent value, notwithstanding a discrepancy between the value of the asset transferred and the debt secured, since the amount of the debt is the measure of the value of the interest in the asset that is transferred. So, for example, you incur debt of $50 million, you grant a lien in all of your assets, which are worth $70 million. That is not going to be a fraudulent transfer, because your obligation is limited to the $50 million, so you essentially have an equity interest of $20 million in the rest of your assets. So that's how it works when sort of there's no mismatch between the person who's granting the lien and the person getting the proceeds of the loan. However, fraudulent transfer risk arises when there is a mismatch between the person receiving the proceeds of the loan and the person that is the borrower, guarantor, or grantor. So as we talked about, this occurs in leveraged acquisitions. It also occurs in recapitalizations or stock redemptions when there's a borrowing to make a special dividend to shareholders or to redeem stock or membership interests. One thing to keep in mind in our loan slide, we had sort of labeled this as a subsidiary guarantee or a sister company guarantee. Keep in mind that this also applies even if you call them a co-borrower. So if the borrower, the sister company, and the subsidiary were all named co-borrowers in the loan agreement, but the person we have named borrower here is the only one receiving the proceeds of the loans, you'll have the same fraudulent transfer risk that you would have if the subsidiary and sister company were guarantors. And then the risk will also apply if you've got sort of other, you have and some other type of affiliate that provides the guarantor who's not getting proceeds of the loans. And then someone, it would also apply in the circumstance where, say, the subsidiary was just granting a lien on real estate that it owned without providing a guarantee or becoming a co-borrower. That would still present the same fraudulent transfer risk. As I noted, in guarantee situations where there is any significant indirect benefit to the guarantor, it is wise to document as specifically as possible, both in the loan documents and in the resolutions approving the transactions, the benefits expected to be received by the guarantor. Okay. In leveraged acquisitions, you got the same risk, and I wanted to note that the risk exists both in typical LBOs, where a private equity company or management is buying the company, and in strategic acquisitions involving an acquisition of a new subsidiary by the operating company. However, typically the risk is much higher in a leveraged acquisition or an LBO than it is in a strategic acquisition. And also note that the precise structure is usually irrelevant. Courts will collapse various steps in a transaction and have invalidated fraudulent conveyances regardless of the structure. So you'll sometimes see people suggest sort of a minute note or some other way of creating debt from the target to the buyer. That generally doesn't work. The court will consider various factors when determining whether to collapse the transaction, including whether all of the parties involved in the individual pieces knew about the other parts, whether each transaction was dependent or conditioned on the other transaction. So in a typical LBO, you will usually have the factors present that the court will find that a collapse is appropriate. There's also an interesting case, so now we're getting into sort of the structuring ways that you can protect yourself. Asset sales versus stock sales. Traditionally, it is thought that asset sales are more are safer than stock sales. However, there is a case in the Seventh Circuit from a few years ago where the company made a dividend to stockholders followed by an asset acquisition, and the court collapsed all those parts of the transaction and found that it was an LBO and a fraudulent transfer. So you're still probably better off structuring it as an asset sale, but at least in the Seventh Circuit, it's not foolproof. And then the sort of the best case scenario for structuring your way around this risk is when it's less relevant to an LBO context and more relevant to the multiple obligor scenario. Basically, if you've got multiple co-borrowers and you're in an asset-based loan, and you can structure it so that you've got a separate borrowing base for each borrower so that you're limited to lending whatever your percentages are of that entity's inventory and accounts receivable. That is one way of ensuring that you're not lending so much to any one company that you're making them insolvent or left with unreasonably small capital. Obviously, another way to go is just to separate, if you've got multiple obligors, to make separate loans. Make a real estate loan to the entity that holds the real estate, make a revolving loan to the entity that has the accounts receivable and inventory, and make sure that those amounts are appropriate to the assets that each entity has. Unfortunately, in many cases, that's simply not practical because the need for the cash is at one entity and the assets are sort of spread out among various entities. So if you can go that route, it's recommended, but it's oftentimes a practical impossibility. Solvency opinions and TUSA. So in some circumstances, particularly in the LBO context, you will see lenders require a solvency opinion to be delivered as a condition to funding the loan. This is usually an option only for larger transactions. You've got, in cases where you're sort of in the typical Wisconsin middle market, usually buyers and sellers simply won't go for the cost associated with getting a solvency opinion. But if you have one, it's going to be good evidence that the company was received fair value and was solvent and not left with unreasonably small capital. These solvency opinions are not binding on the court, but they are useful evidence, and the preparer can be a useful expert witness. So if you do decide to require a solvency opinion, you need to make sure that the firm preparing it is knowledgeable in the industry. So these are some of the factors that came up in the TUSA case in the 11th Circuit when the court was sort of looking at the solvency opinion that was delivered in that case and sort of throwing it out. So make sure that the firm is knowledgeable in the industry of the relevant company and has recent experience performing solvency determination of comparable companies. The firm cannot just like a bank, if you're not getting a solvency opinion and you're doing your own analysis, the same thing applies. You cannot blindly accept the management's projections. You have to analyze them and make sure that the assumptions are reasonable. You also, when hiring a firm, need to evaluate the firm's experience and competence in providing trial testimony when making a hiring decision, because if you get to a point where you're relying on the solvency opinion, the ability of the expert to present at trial is going to be crucial. And if you've got somebody who has prepared lots of solvency opinions but's never been an expert witness at a trial, that is going to be less helpful than someone who has a lot of experience doing that. And then the final factor that was present in the TUSA case, which is sort of mind-boggling, is that do not offer a higher fee to the firm for finding solvency versus a finding of insolvency. That will be looked at very unfavorably by the court. The principal thing that you can do to protect yourself, assuming that the structuring options are not available to you, is to take a really close look at the financial projections. I think this is the single most important thing you can do. Lenders, but also sellers. So even if you're the seller in an LBO, you should take a look at these projections and make sure that you think they're reasonable, because if they find that there was a fraudulent transfer, they can come back and seek to recover from the sellers the proceeds that they got paid. So even though you would typically, as a seller, not care about the performance of the company going forward, in this case you do, because you want to make sure that the money that you're getting stays yours. So the projections have to be reasonable and detailed. The longer the projections go forward, the better. Some case law out there implies that the capital must be sufficient that the company could operate indefinitely. So obviously, 3-year, 4-year, 5-year projections, although they get less useful at that point, are better for you than 1-year projections. And because the central question is often whether the cash flow projections were reasonable, the courts have laid out some specifics for the reasonableness of the projections. They have to be anchored in the company's actual performance. So if your best case scenario shows performance that's better than the company's, if your worst case scenario shows performance better than the company's previous best year, that's going to be a problem. If there are legitimate reasons for expecting better performance, i.e. there are reduced salaries because the former owner was taking some profits out in the form of salary, or reduced expenses such as personal cars or planes, whatever they might have, make sure you document those appropriately. And then in addition to being anchored in the company's actual performance, they have to account for likely difficulties and incorporate some margin for error. So you can't just assume that everything's been going great for 5 years. They've been getting the same approximate level of cash flow profits, and then that will continue for the next 5 years without incorporating, some possible economic downturn, some, loss of the customers, or whatever it might be. Making sure that the projections are reasonable has the added benefit of strengthening the credit analysis, and therefore making it less likely that the company will end up in bankruptcy to begin with. Okay, appraisals. So oftentimes when you're making a loan, you'll get appraisals of the company's assets. The more evidence of the value of a company's assets from independent third parties at the time of the transaction, the easier it will be to build a case for solvency. So you should consider having appraisals cover both the liquidation value, which is oftentimes what banks care about when they're looking at these, as well as the going concern value, because the going concern value, assuming that the company is paying their debts as they become due, the court is going to likely value the company at going concern value rather than liquidation value. So having both of those is helpful in your appraisals. The role of equity and the strength of sponsor. So obviously, the more equity that the sponsor puts in, the more likely it is to be found that they had a reasonable level of capital going forward. The smaller the value, the more likely that they had unreasonably small capital. In one of the case that I mentioned where the Seventh Circuit found an asset sale to be a fraudulent transfer, the buyer put in $5 of his own money in the context of approximately $4 million transaction. So anything that, obviously that's an extreme scenario, but the higher it is, the more likely you are to be safe. You should also consider the strength of your sponsor in terms of if it's someone you have a long history with, is someone that you know that has put money into struggling companies in the past, the farther out you get, the more likely you are to be past the statute of limitations. Even if you're not past the statute of limitations, it's again easier to show that something unforeseen happened if you know, you're 4 years out from the transaction rather than 6 months after the transaction. So selecting sponsors that have a history of supporting their portfolio companies could be helpful. Then if you're the seller, even though this sounds counterintuitive, beware of negotiating too good of a sales price or taking out too much working capital. Obviously, your goal is to get as much money as you can and to get as much cash out of the company as you're able to. But if you get really aggressive on that front, you're more likely to be subject to a fraudulent transfer attack where the court can come back and recover the money from you. So you're better off sort of in the long run getting a good but not too good sales price and leaving the company in a position that they're better able to operate going forward, because then you have less risk of someone trying to recover the money from you if the company does go bankrupt. An additional factor is publicity of the acquisition. Several courts have pointed to a transaction being publicized or hidden as a factor in the fraudulent transfer analysis. So the press release that many purchasers will want to publish anyway is going to be helpful evidence that A, no actual fraud was taking place, and B, that trade creditors were aware of the new ownership and at least had knowledge of the change that could have led them to change credit terms for the post-acquisition company. So if you're in a situation where there's a reluctance to publicize the acquisition as either lender or as seller, that would be a red flag that you should take extra care and try and push to publicize it if you can. Other danger signs. In some of the big transactions that you see where a fraudulent transfer has been found, there's been contemporaneous market commentary that the debt was too much to bear. These tend to be larger deals with publicly held bonds or other publicly held debt. But if you're in that situation, that's a sign that your fraudulent transfer risk is enhanced. In addition, if you've got a bunch of people dropping out from a syndicate or a bunch of people declining to participate, those are going to be types of items that are viewed by a court as sort of contemporaneous evidence that other lenders out there thought that this transaction was too risky and therefore more likely to find that it was foreseeable that bankruptcy could result and that the transaction would leave the company with unreasonably small capital. One interesting thing to talk about, the selling shareholders and the settlement payments defense. So under the Bankruptcy Code, Section 546E provides that settlement payments and transfers made by or to a financial institution in connection with a securities contract cannot be avoided by the trustee. So then that would include avoided as a fraudulent transfer. This provision is generally used in connection with public securities transactions, but courts have also found it applicable to private LBO transactions, although in this case it's going to depend a lot on which jurisdiction you're in. A few of the circuits have sort of applied this broadly and picked up private transactions. Some have not. Unfortunately, the Seventh Circuit generally has not applied it broadly. The Second Circuit, which covers New York, there's a sort of a split in the lower courts, and the Second Circuit itself has not yet addressed the question. So if you can, it's most likely to be helpful if you're using a bank or a financial institution as an escrow agent or a paying agent. So in a LBO, if there's some reason to transfer the stock through an escrow agent or a paying agent, this would be an additional reason to do that. Some courts have gone so far as to hold that merely paying by wire transfer is enough to get you into the settlement payments defense, but that's definitely a minority view. So to the extent, and there's sort of a, they won't, if you structure it in a way to use a financial institution as an escrow agent or paying agent, there's really no reason to do so. You know, they're more likely to sort of see through that and decline to apply the defense. But if there's a reason within your transaction that makes sense for it to happen that way, I would encourage you to use that structure if you can. Okay, and then let's see. So I just wanted to talk a little bit about sort of defenses to the fraudulent transfer determination and why those are usually not available to sellers and lenders in leveraged acquisitions. So the trustee cannot recover from any subsequent transferee that takes for value, including satisfaction or securing of a present or antecedent debt, in good faith and without knowledge of the voidability of the transfer avoided, or any immediate or immediate good faith transferee of such transferee. It's a little bit complicated. The problem with these defenses is that courts have found that knowledge of insolvency will negate the good faith portion of the defense. In addition, if the lender knows that its loan proceeds will not be retained by the borrower or whoever it is, the guarantor or the borrower, then that is also likely to be to negate the good faith portion of the defense. So one of the interesting things about the Tusa case was that the 11th Circuit stated that every creditor has a duty to do some due diligence as to the source of the funds that are satisfying its claim. And they stated this in connection with recovering proceeds from the lenders who are paid off with the proceeds of the new loans that supported the transaction. And this obviously, so if you're a lender and you are the lender to the seller in an LBO, and they get, or in any other type of refinancing transaction where there's multiple obligors, so it could apply either in our just general commercial lending scenario or in the LBO. If you're getting paid off with the proceeds of the loan, typically you just take the money and go away. You very rarely ask about, you know, what's happening, like how is it would be extremely unusual for you to ask about the capitalization of the company going forward when you're the one getting paid off. And so there has been some discussion by commenters about adding provisions to loan agreements that would allow lenders to refuse payments and foreclose on the assets if they think that they're getting paid off with the proceeds of a transaction that would be a fraudulent transfer. But I think in practice that's just not happening, and it's difficult to imagine borrowers agreeing to that or lenders actually using it. I am struggling to imagine a scenario where a lender says, no, I don't want to take your money. I'd rather see you and try and get at the assets. In addition, if you did do due diligence, if you're the lender getting paid off and you did do that type of due diligence and then you found out, oh, the company looks like that this is a transaction that does involve a fraudulent transfer, that is more likely to defeat your good faith subsequent transferee defense. So it's just one of the interesting complications that came out of TUSA. All right, I think that's all I have. Do you have any questions? I have 10 more minutes. Okay, well, are there any questions? Yeah.
How often do you see, if ever, the multiple obligor scenario, the lender requiring the parent to indemnify it for any damages that it would suffer if the transaction, like the loan to the sister company and the affiliates, was voided on fraudulent?
I don't see that very often, because what I usually see is just a simple parent guarantee. And if, I mean, I don't see a lot of value in getting the indemnity on top of the guarantee, because if they don't have the assets to pay on the guarantee, they're not going to have the assets to pay on the indemnity either. And if you've already got them on the hook for the full amount of the loan, any indemnity is likely to get at a shortfall between the proceeds that you got after foreclosing on the guarantees anyway. So the answer is almost never. As long as you're getting a full guarantee. And I don't, where it's sort of structured as a holding company situation, I don't see any reason not to go after a parent guarantee if you can get it. Okay, so the question is, we typically take the current year's performance when looking at projection and model performance continuing at that same level for the next 3 years. Are those likely to be viewed as reasonable projections? And the answer is that it depends on the company. I guess if the current year's performance happened to be a not so great year, and you've got other years that have been a lot better, then using that year going forward is more likely to be viewed as reasonable. If that was sort of the best year that the current year was the best year the company's ever had, then taking that year and modeling it forward is less likely to be viewed as reasonable. And essentially, I mean, this is all getting at the fact that your projections have to account for some difficulties. So if you continue on the current performance without accounting for any difficulties, then those projections are going to be a little bit suspect. Then we've got another one here, which is how much sponsor equity needs to be invested to avoid a determination that the borrower or guarantor had insufficient capital going forward. And the answer is, again, unfortunately, that it depends. There's case law out there on companies that had relatively small capitalization and saying, well, this was not a fraudulent transfer because the company has a very long history of operating thinly capitalized successfully. So the fact that you left it with the same small level of capital after your transaction is not evidence of a fraudulent transfer. On the other hand, it's always better to be more. I think as a general, I think in the 80s you sometimes saw levels of 10% being typical. Now that's pretty unusual. I would say a 10% equity level would be absent circumstances where that's sort of a traditional level for the company. That would be something that's substantially lower than what we typically see in the market, and so that would be a circumstance where I'd say that the risk was elevated. And I think, Nancy, do we have time for one more question? Okay. So the last one, I have here is, so will courts look at these transactions with the benefit of hindsight, or if the will the determination be made at the time that the transfer takes place? And the answer is sort of both. The legal answer is that the determination of whether something is a fraudulent transfer is made at the time that the transfer takes place. But unfortunately, a court is not making that determination when the transfer happens. It's making it 4 years later or 2 years later when the company has gone bankrupt. And so obviously something that has actually happened always seems more likely to happen than it may have when you were looking at the transaction at the outset. So you are sort of in a situation where the court has the benefit of hindsight and is saying, well, you know, obviously the company did go bankrupt, so they're going to be more prone to seeing things that you may not necessarily have focused on as the evidence that the capital was unreasonably small or that insolvency was reasonably foreseeable. And I think that's all the questions I have right now. So